Good afternoon, everyone. I hope you are having a wonderful conference so far. My name is Juharova. I'm a fourth-year PhD student at the Deák Doctoral School of Law at the University of Miskolc, and I'm also an intern at the Central European Academy. First of all, I would like to thank my colleague Gellert for this honor to speak on this panel. Even though I could not join you in person today, I hope this online format won't bore you so much. I will try to be interesting as much as I can. As in my PhD research, I deal with the relationship of new law and constitutional courts and the national constitution. Comes as no surprise that today I will be also talking about the tension between national sovereignty and European legal primacy. But I will be focusing more on the case of the Slovak Constitutional Court. The European Union is founded on the principle that EU law has primacy over national law. However, constitutional courts across Europe have responded differently to this principle, depending on their own traditions, history, and political climate. And Slovakia is a particularly interesting case study as a relatively newer member state. Slovakia entered the EU after a period of rapid democratic transition, and this context shaped its constitutional court attitude. The court wanted to demonstrate loyalty to the European project while at the same time protecting the young Slovak constitution and national sovereignty. The principle of primacy means that when there is a conflict between EU law and national law, EU law must prevail. This idea was first articulated in the Costa versus NL case in 1964. I'm sure all of you have heard about this case. The European Court of Justice explained that its national law should always override European Union law, then the EU integration would be meaningless. This case laid the foundation for a coherent, unified European legal system. And it is important to stress, however, that the primacy is not explicitly written into the EU treaty, but it is developed through the jurisprudence of the European Court of Justice. That means that primacy rests on the judicial reasoning rather than a clear treaty text, leaving some space for national constitutional courts to raise objections or interpret it a little bit differently. And as a result, many national courts, especially constitutional courts, have insisted that primacy must always be interpreted through the lens of their own constitutions. This tension is at the heart of today's discussion. The Slovak Constitutional Court has consistently emphasized that Slovakia remains a sovereign state. Article 1 of the Slovak Constitution explicitly says that Slovakia is a sovereign republic. And while the country accepted the obligations of the EU membership, including the application of EU law, the Constitutional Court insists that this does not mean that Slovakia has given up its constitution. Instead, the court reserves the right to protect the core of the constitution, particularly when fundamental principles or national identity might be at risk. And this has given rise to what the court calls control competence, the authority to review EU measures and check whether they are compatible with the constitution. Next, I will talk about a few important cases that were dealt with by the Slovak Constitutional Court in this subject. The first one is the Lisbon Treaty case from 2009. And in this case, the Lisbon Treaty was a turning point in European integration, and it created the position of the President of the European Council, strengthened the European Parliament, and extended the EU's powers in areas such as foreign policy and justice. In Slovakia, opponents argued that transferring such powers threatens Slovak sovereignty, and the Constitutional Court ruled that the Lisbon Treaty was compatible with Slovak constitution. However, the court was careful to stress that Slovakia had not surrendered its statehood. Most importantly, the court declared that it had the right to review future EU measures for compatibility with the constitution, and this mirrored the German Constitutional Court Lisbon decision, which also insisted that the core constitutional powers must remain in national hands. And this case was significant not only for Slovakia, but also for the broader European conversation. It showed how new member states could adopt arguments developed by other, more established constitutional courts. The second case was the sugar quotas case, also from the same year, and it involved sugar production quotas under the EU's common agricultural policy. For Slovakia, this was more than just an economic issue because it raised questions about who gets to decide economic policy. And some Slovak producers argued that the European Union quotas violated Slovakia's sovereignty in regulating its economy. And the Constitutional Court acknowledged that the EU membership necessarily involves transferring some regulatory powers to the EU, especially in agriculture. However, it also stressed that such transfers are always conditional and on respecting the Slovak constitution. Sovereignty, it explained, is not lost, but rather shared and exercised jointly with the EU framework. This reasoning is a good example of how the Constitutional Court's balanced approach, respecting EU primacy while reminding everyone that Slovakia's constitution remains the ultimate reference point. The third case is the European arrest warrant case, which was this European arrest warrant was designed to make extradition within the EU faster and more efficient. However, it also raised concerns about whether the suspect would enjoy fair trial in the requesting state. And in Slovakia, critics fear that surrendering Slovak citizens under this warrant might violate constitutional guarantees of fundamental rights, and the Constitutional Court upheld this warrant, but added that there is a crucial safeguard, which is Slovak courts must always ensure that extradition does not violate human dignity or the prohibition of retroactive punishment. In other words, the Constitutional Court accepted EU obligations, but insisted that certain core rights protected by the Slovak Constitution could not be ignored. And this case highlighted a recurring theme that Slovakia is committed to the European integration. However, it draws the line when fundamental constitutional values are at stake. The fourth and final case that I will be talking about is the judicial independence case. This case is from 2014 and arose during disputes over judicial appointments and disciplinary procedures within Slovakia. And in its judgment, the Constitutional Court made reference to the EU standards and ECJ ECJ case law, but it ultimately grounded its reasoning in the Slovak constitution, and the court emphasized that EU norms should guide interpretation but not replace constitutional guarantees, and also showcased this case also showcased the constitutional court's approach, which was that it was willing to engage in dialogue with the EU law, but it firmly reserved final authority for itself. And to summarize, the Slovak Constitutional Court's case law, taken together, these four cases reveal a consistent pattern, which is that the court recognizes the necessity of EU primacy, since without it, EU law would be ineffective. However, the court also treats primacy as something conditional and not something absolute. And it accepts EU law where it fits within the constitutional limits, but signals readiness to push back if those limits are crossed. And this, how we call it, conditional loyalty, is the hallmark of the Slovak approach to European integration. In this part, I will shed light on tensions in practice and also some implications for EU integration. So, firstly, the practical challenge is how to balance EU obligations with constitutional safeguards, and disputes arise when EU law requires Slovakia to implement rules that may appear to conflict with domestic constitutional protection. And the constitutional court, like other constitutional courts, has to walk a fine line when defining its constitutional identity. And the Slovak experience illustrates both the strength and the fragility of European legal integration. On one hand, EU primacy is widely accepted in practice, which allows for a coherent legal system across member states. On the other hand, the insistence of national courts on constitutional safeguards reminds us that integration cannot be absolute. And the Constitutional Court jurisprudence reflects a model of constitutional pluralism, and this model emphasizes that the EU and the national legal orders must coexist in a dialogue rather than in a strict hierarchy. And it also highlights to a deeper point that sovereignty cannot be fully transferred to the EU without risking democratic legitimacy in member states. And by maintaining its cautious stance, the constitutional courts have to preserve the effectiveness of EU law while also ensuring the constitutional identity remains protected. To conclude, the Slovak Constitutional Court embodies the broader European dilemma of sovereignty versus primacy. EU law seeks uniformity, but national courts safeguard constitutional identity. And the Slovak Constitutional Court case law from the Lisbon Treaty decision to the sugar protect dispute and the European arrest warrant demonstrate that European integration is not about unconditional supremacy. Instead, it is about maintaining a delicate balance. And that balance ensures that the integration is both legally effective and democratically legitimate. So I hope that you enjoyed my presentation. Thank you very much for your attention. And as unfortunately I cannot partake in discussions, in case of any questions, remarks, please feel free to write on my email address, which is on the screen. And I wish you all a wonderful conference and enjoy your time in Budapest. And I hope to see you next time in person. Bye bye.